Always. Hello, everyone. Welcome to the afternoon docket for the Court of Appeals November 15th session. I am your presiding judge, Leslie Isherwood, and basically that just glorifies my role of keeping time for everybody. To my left is Judge Tim Leahy. He was a district court judge in Sedgwick County for 27 years before retiring in 2017. And we are fortunate enough to have him as a senior judge for a second term. Gordon Atchison would be to my right, but he is appearing via speakerphone because of car trouble this afternoon. So he will be at the podium with the parties as they argue. We have two cases on the docket this afternoon. They are 15 minutes aside. If you are the appellant, please request rebuttal time if that is your desire. Also, in preparation for today's arguments, we have thoroughly reviewed the brief and the record, but any individuals who are watching online are not similarly situated. So I would ask the appellant, when you come to the podium, to kind of give us 1 to 2 minute discussion of how it is we got here so that anyone watching has some context to the cases that they're watching. Good. All right, with that, I will call our first case, 124528, Neil Litke versus the Board of County Commissioners.
He's going to be here on the speakerphone. If you need to fiddle with it, feel free to.
May it please support Ryan Kriegshauser and Dr. Nye on behalf of petitioner Neil Litke.
William A. Casbaum, County Councilor, Morris County, representing the County Board of Commissioners.
Kriegshauser, if you'd like to begin.
You Judge Isherwood, if I could reserve 3 minutes
2 minutes.
for rebuttal. Let me see if I can move this phone without disconnecting it. And then will that clock keep time as well?
I
Or
will be keeping.
okay, I might do the same just so I know I know where I'm at, just so I don't run over. I have some idea here. May it please the court. Well, this case appears to be about a mask order. It's really about whether the legislature can create a meaningful process balancing individual rights with government action through judicial review, or if the defendant can use gamesmanship to issue broad orders and wield extraordinary emergency powers. And to meet the court's direction, to give a little background for those who are not familiar with the briefs, this case is essentially an appeal of a mask order out of Morris County. There's a procedure created in law that I'll discuss here briefly that was put into effect in 2021, SB 40, that created a possibility for an aggrieved citizen to bring a case in district court to challenge a COVID order, any public health order. This one just happens to be a mask order. And so that was brought to district court, and Judge Sexton found the county, it is their burden to show that it's narrowly tailored and uses the least restrictive means. And Judge Sexton found that the Morris County order met that standard, and that's why we are on appeal. So COVID is still here. On October 13th, the United States extended its public health emergencies for 90 days into next year. If you Google COVID, it's still in the news. You just heard Canada talking about whether Ontario should issue a mask order. They ultimately didn't. But suffice it to say that this is still a problem. It's still present in society. There's been open discussion about whether there was government overreaction during COVID. In fact, a couple of weeks ago, The Atlantic magazine issued an article saying entitled, "Let's Declare a COVID Amnesty." But before the Atlantic was looking at that, the Kansas lawmakers were very sensitive to potential overreactions, and Kansas law throughout the pandemic was changed multiple times. 2020 HB 2016 took away the unilateral power of a local health officer to issue unilateral public health orders that could keep people in their homes, lock people in their homes, could shut down businesses. These are extraordinary emergency powers, and the legislature said, we don't know that it's a good idea to have one person wielding these powers, and they let the county commissioners review those orders. But going as the pandemic drove on, there was legislative action that culminated in, as I mentioned, 2021 SB 40. And really through litigating, we've done a number of cases through COVID, there has been a dearth of any court authority. I mean, it's very limited, particularly in Kansas, but nationwide, there just wasn't, we weren't prepared for the pandemic, both as a society and certainly not legally. Some of these statutes have been around for decades, but are untested, particularly the Chapter 65 statutes dealing with quarantine and isolation procedures. How does a 65-129 hearing, 72-hour hearing in a quarantine procedure work? We were just doing them for the first time, and we didn't have any guidance from an appellate court. And that's really why we are here today. This case presents a question both on the jurisdictional issues presented and the application of SB 40 itself, whether the legislature actually meant narrowly tailoring, and whether it meant least restrictive means when it wrote that into SB 40. Because our position is that Judge Sexton's order did not apply what we know as strict scrutiny. As it's commonly said, strict scrutiny is strict in theory, fatal in fact, and very few things survive strict scrutiny. And so our analysis of Judge Sexton's order isn't that rigorous a review that you would expect to see in many constitutional cases applying strict scrutiny. So it begs the question, did the Kansas legislature mean something different than strict scrutiny when it said law must be narrowly tailored and be the least restrictive means?
Mr. Creechhouse?
Yes, Judge Atchison.
The mask mandate itself, was it in the form of an order or a resolution, or I have forgotten how it was characterized on its passage?
Yes, Your Honor. I think originally it was an order from Dr. Freeze, but then the county commissioners, we objected to that because of 2020, 2016, which I mentioned, that took away that unilateral power. And I believe the county commissioners held a special session a day or two after our objection, and then issued it as a resolution essentially from the county.
Okay. And does the resolution, or did it include some penalty for non-compliance?
So these orders are out of Chapter 65, 201, I believe, is the statute that allows them to be issued. The resolution itself was clearly a mandate, but it didn't express what the penalties for violating it were. But I do believe that Chapter 65 itself has a general statute for violating any order, public health order, that is, I believe, a misdemeanor, Your Honor.
Okay. And it's your position that that would apply to a violation of this order? Yes,
Your Honor, that is our position. This was clearly issued as a mandate. And if you look at most of the testimony in the hearing, Dr. Freeze was very clear that this was intended to be a mandate, because we asked about whether or not recommendations couldn't be given. And Dr. Freeze essentially said, I tried that, people wouldn't listen. And so this mandate was issued. But he did concede that the sheriff wouldn't enforce it. And there was no good enforcement mechanism, which is one of the reasons we argued, if you can't enforce it, why not just issue a recommendation? But it technically could be enforced, Your Honor.
Okay, thank you.
So just to give a little background on SB 40, it creates a procedure by which any aggrieved party, and that's very broad, and we got into that a little into our briefing, could bring a case. And the district court overruled a motion to dismiss that we were not adequately aggrieved. And we had some discussion of what the definition of aggrieved is, because SB 40 doesn't really define what an aggrieved person is. But there are other places in statute that do. But to boil this whole case down, I think it really does turn on jurisdiction. The defendant has raised questions of both standing and mootness. And I think the standing argument is really a red herring in many ways. They cite Baker versus Hayden. And really, as I read the defendant's brief, they are objecting to statutory standing rather than general standing. In their brief, they pretty much concede that we at least had standing at one time, and so we were subject to the order. And when you look at the core of common law standing, you have to show a cognizable injury to the party suing and a causal connection between the injury and the challenge conduct. And that's from Sierra Club versus Mosier. We also included that in our briefing. And really, that's the issue here. In standing, it's the plaintiff and their proximity to the contested action, and that nexus between the person suing and what they're aggrieved by. And there's no question that our client was under the order and could be under the order. And that's one thing that I think it wasn't mentioned as much in the defendant's brief, but being under threat of future possibility is also a way to achieve standing. And you see that in a lot of like Sierra Club versus Mosier, where you have an environmental group saying there's going to be environmental impact. So there can be
a legitimate.
Yes.
And
yes.
how is there a legitimate threat in this case?
Well, it's or. And so we had an actual harm being under the order, and there then a threat, a possible threat, and the county could issue an order tomorrow. I mean, there's nothing to stop them on any health emergency. And that's a problem with a pandemic. And that's one of the reasons why this is an issue of such public importance, that the court needs to weigh in and say how this process should work, because we weren't prepared for the last one. And if courts don't get involved and tell us how these processes work, we won't be ready for the next one. And it's not a question of when, it's if. I mean,
but can we really do that here? I mean, isn't this really kind of a moot issue now that the mask mandate is no longer in place?
Well, and that gets to the heart of this, Your Honor. As I said, I think standing is a red herring based on the Baker case. In that case, it was a core request, and the plaintiff got the recordings he was seeking. Here, we haven't got what we asked for in the petition. What we asked for in the petition was for a court to narrowly tailor the order and show us what a narrow tailor order is. We didn't say get rid of the order. We said narrowly tailor it, and please show us what a narrowly tailored order looked like. And so we'd ask the court to apply the exception to mootness. Unlike standing, mootness is not jurisdictional. I think in the Roat case just coming out in 2020, with mootness, Kansas law has been very confusing over the years, but in Roat, they came out, the Supreme Court said, this is not jurisdictional. This is providential for, not providential, but discretionary for the court. And in situations like this, where I think this is the only COVID case that is alive right now. The Klingon-Smith case in Johnson County has been dismissed. The Butler case that went up to the Supreme Court to decide whether or not the constitutionality of SB 40 was wrongfully invoked by Judge Haber in district court.
How do you get around mootness here? What is your exception that's applicable here?
The exception is capable of repetition and of public concern, which is set out often. We mentioned it from State versus Montgomery, but there's a clear exception for this. Is the perfect situation for a case that is possible of repetition yet evading review.
But isn't the
Mr. Creehauer, how isn't that though a very fact-specific circumstance? It depends in part on the health crisis the order is intended to address, and in turn, what the order or the mandate requires. In some part, Your Honor, but I think the exception is broader than that, when it can dictate what future individual behavior should be. Of course, this is of public concern. The legislature has enacted laws in response to both these orders and the pandemic in general multiple times, and the governor has signed those. The entire society was captivated by this pandemic. I think if this doesn't meet the exception for a public concern and possible of repetition, it's hard for me to imagine something else that would be.
Who
Well,
established?
I guess I'm confused by, I mean, do you want us to decide it based on what the circumstances were at the time the order was issued or the time that you filed the challenge to it?
No, I think the question of mootness, I think, and my time is up here, so I'll defer to the court. May I answer?
Finish your
Okay,
thought, and you're free to go forward or
Okay.
save your time for rebuttal. It's entirely up to you, but if you'd like to just finish.
yeah, I'll just finish this thought. I think the problem is there is a question of mootness here because the order has been withdrawn, but that will always be a question. And almost every one of these cases have gone away because of mootness. And it's easy for, I feel like it's Lucy trying to kick the football in Peanuts, where the case is out there, the order's out there, you come up and you try and get reviewed by a court and they withdraw the order. And that seems, why this exception for mootness is created. So I think there is a mootness issue, and I'll admit that to the court. I want to be candid, but I think this exception perfectly fits the situation.
Before you sit down, but what is it you want us to decide in light of the order having been lifted, and we don't know what the next health crisis or pathogen will be that will prompt an order, or what will be in the order. What you're asking us to do seems very abstract to me.
No, I think our client had one main complaint, and that was this Morris County order had no end. It was indefinite. Most of the county orders had 30 days. And the reason the county did this, and why I said it was gamesmanship, is there is a requirement at SB 40 to bring an action within 30 days. That was uncomfortable for county commissions because people did not like the orders, and they would come and let themselves be heard at county commission meetings. And so what counties began to do is make longer and longer orders, almost a year long in Johnson County and Morris County. It just had no end until Dr. Freeze decided he wanted to release everyone from it. And that was our client's major complaint, is that an order is perpetual. And is that narrowly tailored? And we suggested it was not. And we suggested a 30-day order was reasonable. The county commission met every week and they could review that order. And so that's our client's main concern is a perpetual public health order narrowly tailored and the least restrictive means? And we'd submit, obviously, it's not.
Thank you.
Thank you, Your Honor.
I'll start off with, I don't believe the court has jurisdiction to hear this case. And the reason is the lack of standing by Mr. Lidke. I agree, Mr. Lidke had standing to begin with, statutory standing. The statute 65201D1 says that any party aggrieved by an order can file a suit. The statute doesn't say any person can file a suit. It says an aggrieved party. The statute doesn't define what aggrieved is. I raised that at trial with a motion to dismiss, what's aggrieved. Counsel for Mr. Lidke said aggrieved is any resident of Morris County who has to abide by a mask order. The court seems satisfied with that, the district court. That's fine with me. That's an aggrieved person under the statute. Then they have to abide by the mask order. And
Mr. Casabon,
yes, Your Honor.
I posed you the same question I posed earlier. Did the resolution have a penalty provision for noncompliance, or was there some other provision that applied a sanction for someone who did not comply?
No, Your Honor. And it was not a resolution. It was a mask order by the county health officer. The commissioners did approve the order as required by statute, but it was a county health officer order approved by the commissioners. There's no penalty provision in it.
Well,
Counsel's correct that under
in place, was Mr. Lidke subject to some kind of fine or other penalty for non-compliance? Or could he have been subject to it?
could he have been? council is correct. Under the statutes, there can be a misdemeanor for violating one of these type of orders. However, there is testimony in the record where the county attorney refused to prosecute any cases, and both the PD, Council Grove Police Department, and the Morris County Sheriff's Department refused to do anything as far as enforcing the mask order. So in a practical sense, the county was not doing anything to enforce the mask order.
Thank you.
Having statutory standing, the case proceeded. On January 11th of 2022, the Morris County Commissioners rescinded the mask order. At that point, then nobody in Morris County has to abide by a mask order. There would not be any aggrieved person. Mr. Lipke no longer has to wear a mask to go to the store or to watch his kids or go to the gym, and therefore he's no longer aggrieved under the statute. So if he doesn't have statutory standing, then you have to look at traditional standing, which requires he either suffered a harm or a threatened injury that, as you're correct, a legitimate threatened injury. And the record's silent on that. There is none. He complained that he didn't like to wear a mask going to the store, didn't like to wear a mask going to the gym, didn't like to wear a mask to watch his kids play sports. Didn't say he was prevented from doing any of those things. He just didn't like to wear a mask to do them. There's no harm. There is no injury. There's nothing that rises to the level of traditional standing. If he lacks traditional standing and the statutory standing has gone away, then Mr. Lipke no longer has standing, and this court no longer has jurisdiction. It's similar to conclusions found in the Baker case that I've cited, that you can lose standing in the process of litigation, and that is what has happened here.
What is your response to counsel's assertion that he can circumvent mootness by the exception that it's capable of repetition?
Well, is it capable of repetition? Can Morris County issue a new mask order? Yes, legally, that is a possibility. Is it likely to happen? Haven't done it in the last 8 months, 10 months, or whenever, from January to now. Cases had risen in Morris County back in August. They didn't do anything to do a mask order, and there is no talk of doing a mask order. So
when we talk about capable of repetition, how narrow do we look at that? Capable of repetition in the exact form that the mandate was in, or just capable of repetition in the sense that any type of mandate could be issued?
Well, Your Honor, I don't know how to answer that, to tell you the truth. There's new personnel on the ground. If you've read the record of the case, Dr. Freeze's testimony,
I guess what I'm asking is from a legal perspective.
yes.
With respect to that exception, do we look at it as that exact mandate is capable of repetition? Or is it just the institution of a mandate is capable of repetition? What is the lens we should be looking at?
Well, I think you're confined to the record, and it would be the exact same task order. Is the only answer I could come up with. To the issue of mootness, as already discussed, they've conceded that there is no longer a controversy here because the mask order has been rescinded. Reading counsel's brief, what they're asking for is basically an advisory opinion. There were no harms or infringements on Mr. Lipke's rights. The record is silent to anything like that. I don't, to address your questions, I don't know what you would address in an opinion. he didn't like to wear a mask. And that's been taken care of because the mask order is gone. So what they are asking for is an advisory opinion on time limits or exceptions or any of that, because none of that exists anymore. And the record was silent on all of that. To council's issue of a 30-day time period, because the statute requires a petition to be filed within 30 days of the mask order. I don't buy that. If somebody is truly harmed by a mask order, their fundamental rights have been infringed on, they don't have to use this statute to challenge a mask order. There are other legal actions one can take. 1983 actions, tort actions, not this statute. This statute truly deals with somebody who's aggrieved, which doesn't really mean somebody's been harmed or anything's been taken from them, but they have 30 days under that statute. Mr. Litke also could have come to the county commissioners, as council said. Commissioners meet every week, and voiced his frustration with the order. Many people did. As all other counties had mask orders, it was a very contentious time. People let us know what was going on and they didn't like it. Commissioners eventually rescinded the order. That's the true remedy for an aggrieved person like Mr. Litke, is through the political process, unless they've suffered some real harm. And then, as I mentioned, there's other avenues that they could use besides this statute. So as the record shows, the testimony from Dr. Freeze and also from the hospital administrator, 30 days on an order is just truly arbitrary. You need to look at the trends. When the trends go down, you can get rid of that mask order. That's what the health professionals recommended. That's what's in the record. I think it would have been arbitrary for Judge Sexton at the district level to impose any kind of time limit. And I think it would certainly be arbitrary. And again, I really don't know what you all would do, mandate this back to the district court for an order that's been gone out of existence for the last 10 months to revise that order. I don't know. I see difficulties.
Mr. Casabon?
Yes, sir.
Can I ask you a question about, I don't know that it's precisely germane in this case, but it occurred to me in looking through all of this. And I've forgotten the date that the order was adopted by the county commission. But what if somebody moved into Morris County 35 days after that? Would they have standing as an aggrieved party to challenge the mask mandate?
No, Your Honor, I don't think so. Under the statute, it's measured 30 days from the time the order was given. And I think that's consistent with the rulings in some of the Johnson County cases. The one that was eventually up to the Supreme Court, where he ruled that the mask orders were actually beyond the 30 days, and so they couldn't avail themselves of that statute.
Okay.
If there's any other questions, I'd be happy to try and answer.
Any other questions?
Thank you.
Thank you.
How much I'm doing?
5.
Just a few things. So, like I said at the beginning, I think the defendant's argument really is statutory standing, not this general standing, because they admitted that we had standing. And I don't see how the Baker versus Hayden case changes that, when in that case, someone got exactly what they were looking for. In our case, we haven't yet, because there's been no narrow tailoring of the order. And saying that we lost our aggrieved status, it violates the rules of statutory construction because it really renders SB 40 a useless appendage of statute, because you can't get review on these, especially from an appellate court. It just takes too long, as we've seen in this case. And there's Kansas public employees. There's a presumption that the legislature does not intend to enact useless or meaningless legislation, and construction of a statute should be avoided when it rendered the application of a statute impractical or inconvenient, or which would require the performance of a vain, idle, or futile thing. And so saying that someone can lose their aggrieved status without getting review would render SB 40 useless, which is probably an important thing for the legislature to know, is that they need to change SB 40 if the definition of aggrieved can be lost, and they need to specify whether or not they believe that to be the case. But really saying that a person can be aggrieved, even though I talked to my client today, he's still very much aggrieved that he lived under a non-narrowly tailored order for 6 months. That's why he wants us to continue this appeal. And that's why I'm here before you today, is because he continues to be aggrieved because that order was in place and he lived under it. And so I think really the issue here, as you all have pointed out, is mootness and whether or not an exception applies, and in whether or not to interpret the order as it is. State v. Hilton, I think a lot of these mootness cases involve criminal law, where a person serves their sentence and then, appealed it, then served their whole sentence before it took the case to get up on appeal. And I think in that case, it was clear that the construction of law, it was a parole case. It's more about how the law works, because you're not going to have the same exact parties. You're not going to have the same Dr. Freeze. Does he have to be involved? Does it have to be the same virus? It's the principles of the order, and an indefinite order is very capable of repetition.
Well, and that was the question I was posing to opposing counsel, is if you're trying to execute that exception, what are we talking about when we're talking about capable of repetition? Is it capable of the identical order? Or are we just speaking in terms of generalities that someday, somehow, an order may be reinstituted?
No, you have to use, I think, the Morris County order as a basis. And are there things in that order that are not narrowly tailored and not the least restrictive means?
The Dr. Freeze isn't even there anymore, is that?
No, well, and actually that brings me to another point about voluntary cessation. I mean, is that what occurred here? Because in the minutes, there was actual medical advice when they repealed that order. A doctor protested, and at the end of the meeting, Dr. Freeze resigned. And so then a month later, counsel for the defendant filed a motion in the district court to get those minutes into the record because he wanted to argue mootness on appeal. And voluntary cessation is a doctrine where if the reason that the conduct stopped was to moot an appeal, then there's another exception, is voluntary cessation. And by the minutes, there was not a medical scientific reason to remove that order, but we had docketed our appeal. And so why did they withdraw that order? It wasn't, I mean, the doctors protested it, and you had Dr. Freeze ultimately resign. And that's another issue that we brought up in our brief. So I think mootness, it's not jurisdictional, it's discretionary for this court to determine whether this issue is of sufficient weight. Because as defendant cited Jacobson v. Massachusetts, the famous Supreme Court case that repeatedly came up in the pandemic, it was from 1905. And it became incredibly relevant in 2020, and everyone was citing it. It was a vaccination case. And so we have no law. When you look at a lot of the Chapter 65 case law on this, it's back in 1915, and that doesn't help you in today's society on what constitutes a proper pestilence house. But that was the law we were working with, and our legal system was not prepared for this, and our legislature tried to take affirmative steps. And if our appellate courts won't weigh in on what is proper and improper, we're going to be in the same situation next time. And I think that's of great public importance and concern.
Your 5 minutes has lapsed. If you have a couple thoughts that you just want to wrap up with, you can.
No, Your Honor, unless there are questions, happy to answer them. Thank you.
Thank you both for your arguments. We will take the matter under advisement and issue an opinion as quickly as we can.
Thank you,
Thank
Judge.
you.
It's good to meet you.
So our second case will not be heard today. The second case on the docket. So we will proceed to case number 124160, Benchmark Property Remodeling LLC versus Grandmothers Inc. For First Bank and Trust, Kansas Department of Revenue, Robert Zabel, and State of Kansas. Yes. And we'll move a little closer to the mic. I noticed I was offset earlier.
Good afternoon, Your Honors. I'd like to reserve 3 minutes for rebuttal.
3 minutes is reserved.
May it please the court. My name is Diane Lewis, and I'm here representing the appellant Benchmark Property Remodeling. This is a construction case, and for a little bit of background, my client Benchmark was familiar with some individuals of the Kansas Department of Revenue and a property owner here in town known as Grandmothers Incorporated, which is owned by Mr. Bob Zabel. And in early 2018, my client had connected with someone at Kansas Department of Revenue to go over some remodeling that KDOR wanted to do in a building that it was leasing from Grandmothers Inc. KDOR has been in that building for some time, and they are currently in that building today, as far as I know. My client spent 8 or 9 months coming up with a very specific and detailed scope of work of the work that KDOR wanted to do. Mr. Macbeth, who's the owner of Benchmark, was in contact with Mr. Zabel regarding work to be done at his property. He was Mr. Zabel and Mr. Macbeth had done work before and were together and were familiar with each other. And in August and September of 2018, Benchmark put together a very detailed scope of work of about $136,000 of construction work that KDOR wanted done for the property it was leasing from Grandmothers. Grandmothers it was very well aware that work was going to be done in its building. KDOR told Benchmark, "You've got the job, you can do the work." KDOR went to Grandmothers, amended its lease, attaching Benchmark Property Remodeling's quotes to the lease, saying, "Hey, we're going to pay $136,000. And then they had some other agreements amongst themselves that was only relevant to the lease. Benchmark was allowed to come into that building almost every single day to perform construction work for 3 months. They completed the construction work. KDOR said, "Yes, this work is acceptable to us. This looks great. Release payment." Grandmothers made the first payment to Benchmark Property. Then when the second payment came in, but Grandmothers held back the money and said, "No, actually, we want a 5% retainage. We want you to pay some attorney's fees. We want you to pay some costs that we've incurred that weren't authorized by the state. And we're going to hold back 10% retainage, even though the construction work has already been accepted as complete." My client and Grandmothers had a dispute about this. Grandmothers was basically trying to withhold about $20,000, required my client to file suit, at which point Grandmothers went and tracked down some of my client's subcontractors, made some payments directly to subs, made a payment directly to Grandmothers, but still held back $20,000 from the amount that that Benchmark had negotiated in this deal. So Benchmark continued to pursue its lawsuit. KDOR had filed a motion for judgment on the pleadings, claiming that looking at the pleadings, there was no valid claim, which the court granted. Then Grandmothers filed a motion for summary judgment, claiming that there was no contract between the parties, and the court granted that later, which is where this appeal results. And the issues we've got on this that I'll address on both points is that the court's entry of judgment on the pleadings with respect to KDOR is in blatant violation of the standard of review for judgment for pleadings, judgment on the pleadings. For a judgment on the pleadings, a court is strictly limited to looking only at the petition that's been filed. In our case, the second amended petition, which explicitly alleges that there was a contract between Benchmark, Grandmothers, and KDOR.
Wasn't the work already completed? I mean, wasn't KDOR kind of out of the doghouse at this point, and the real dog fight is between Benchmark and Grandmothers?
No, and that's an interesting point. So the Grandmothers, or excuse me, Benchmark gave the quotes to KDOR. It agreed to perform the work for KDOR. All three parties are there together at the beginning. At no point did Benchmark ever agree that it was going to rest its entire hope for payment on Grandmothers. The fact that KDOR and the state of Kansas are standing behind Grandmothers saying, yes, we want you to come in and do this work for us, that's a very important fact, I think, and a very important, meaningful thing to my client, because if the state of Kansas is involved, you shouldn't be wondering whether or not you're getting paid. And for the state of Kansas and KDOR to say, well, we're going to offload this burden of payment to this landlord who ends up not even paying the poor contractor, that's not something that my client ever agreed to. That's not something that KDOR can unilaterally offload on someone. And I think it's pretty clear in the law that you can assign the obligation to make payments to someone else, but that doesn't get you off the hook. So I think the issue there is that KDOR, they can make an agreement that they're going to pay Grandmothers, and between the two of them hope that Grandmothers pays Benchmark. But if Grandmothers doesn't follow through, that doesn't get KDOR off the hook. And with respect to, as it applies to judgment on the pleadings, that's not even something that the court reaches. With respect to judgment on the pleadings, at that stage of litigation, the only thing the court can consider is, does the petition claim a valid cause of action? And in this case, it absolutely does. Benchmark alleged that it had a contract with KDOR and Grandmothers, that it was a three-part contract. And what's significant about that is not only does the review of a judgment on the pleading, motion for judgment on the pleadings require that the court accept that as true, KDOR admitted that in its answer. And that is crucial because that's an unequivocal, that's an unequivocal concession of its truth. So what we have is an unequivocal concession by KDOR that it had a contract with Grandmothers and Benchmark. It can't come into the court and say, well, you know what, really, if you want to, why don't you look at this lease? Why don't you look at these other things? Why don't you consider how this contract plays together? We don't even reach that. And that's the issue with the judgment on the pleadings, is that that's not something that the trial court could even consider. So when we get an order and the trial court comes down with an order and says that there was no meeting of the minds and that there's no documentation of a contract, those aren't things that a district court can consider for a motion for judgment on the pleadings. You're looking at the face of the document. Does it meet the standard, yes or no? And so when you've got somebody that's saying, well, I don't think there was a meeting of the minds and I'm not seeing any documentation of a contract, those are both, I mean, right off the bat, those are red flags that the standard's not being adhered to. Now, and the court also made the comment included in its order that it would not look beyond the lease. And there was some confusion about the lease itself. I'm not claiming that Benchmark was a party to the lease. That's something between Grandmothers and KDOR. I think that the lease is significant in that it backs up my client's explanation that it provided this detailed quote. It shows the work to be done. It shows the amount that it was going to be done. There's no dispute about any of those issues. It's just after he's now spent several months putting that together that there's a question on payment. So With respect to the judgment on the pleadings, I think that this court has unlimited review in taking a look at that issue. And I think that the court's order is clear that it's not following the law when reviewing those motions, and that the record is clear between the second amended petition and KDOR's answer that there is a contract that overcomes that standard. With respect to grandmother's motion for summary judgment, the trial court concluded that that there was no meeting of the minds, which on a motion for summary judgment, court's got to find that there's no genuine issue of material fact. It's got to resolve all issues in favor of the non-moving party, or it's in light of the non-moving party. And what we have here is the district court interpreted the party's intent. And that's not something, that's an absolute determination of fact that you can't do on summary judgment. And not only that, with respect to that, the court's order, which is attached to my brief in the appendix, noted that the court finds that there was not consideration or a meeting of the mind sufficient for a contract to form, particularly because when Mr. Zibel and grandmothers tried to take over some of the construction halfway through and were told by the lessee, which was KDOR, no, hey, we didn't authorize this. We've already contracted with Benchmark to do the work. And now I've got a situation where I can't get payment from KDOR because they're saying, no, you need to go get this money from grandmothers. And then I'm being told, well, no, you can't get this money from grandmothers. You've got a contract with KDOR. Both of those things cannot be true. And my position on that is it's not a situation where neither of them are liable. They're both liable. This is something that can be worked out. And why this situation gets to be significant, also cited in my brief and attached in the appendix were two cases, Hilton versus No Block and VHC Van Height Construction, both of which interpreted the Kansas Fairness in Private Construction Act. And the Kansas Fairness in Private Construction Act is a statute that's designed to ensure that subcontractors and contractors get paid on construction projects. It's under 16-1801 and following sections. And it explicitly prohibits contractors and owners from withholding retainage improperly. It caps retainage at a rate lower than what we have in this case. It allows for attorney's fees, and it allows for 18% interest on amounts that are unpaid. And where that's significant is if you look at the Hilton case in particular, you have a subcontractor that's going to perform work on a bigger construction project. There's no written contract. There's really not a dispute as to how much work it's going to be, only about $12,000. But the contractor gives the guy the runaround, forces the sub to file suit, and then after some period of time of litigation, the contractor said, oh, whoops, my mistake. I'm willing to pay your $12,000 here. And what's significant is the district court and this court said, no, that's not enough. That's not what the rules are here. You had a contract with this sub. The Kansas Prompt Pay Act does not allow you to jerk them around for a year and then only to admit the amounts that are due. And that's really what we have going on here with respect to grandmothers. We went from $114,000 being owed when suit was initially filed. Grandmothers made a couple payments to some subs. Grandmothers made a little payment to Benchmark, slowly reducing the amount owed, hoping we're going to go away. Finally makes, I think maybe 2 years into litigation, says, okay, well, here's an offer of judgment. Even that wasn't for the full amount owed. Then a couple months later, makes another small payment, just chipping away at it. And that is the epitome of what we have this Kansas Fairness and Private Construction Act for, is to ensure that contractors get paid in full, and that if they don't, that there's adequate remedies to enforce that. So I think I won't rehash what I addressed in my brief on that regard, but Kate or grandmother's argument that they've made an offer of judgment, first of all, it's not admissible as evidence of anything except at the end of the day when reviewing costs. But that argument has been evaluated and rejected in other cases. That's not something where you can just come back and say, sorry, I'll make it all better by paying the original amount owed. So, and I don't know how much time I've got left.
You just started into your rebuttal.
Okay, well, then I would just say, unless there's any questions, we would ask that this court reverse the district court's order granting KDOR's motion for judgment on the pleadings, and reverse the district court's order granting grandmother's motion for summary judgment.
Thank you.
May it please the court, Adam King appears on behalf of the Kansas Department of Revenue in the state of Kansas. The department is here to argue that even looking at the face of the pleadings themselves, Benchmark has failed to make any allegations showing that the department should be liable. I think that's a relatively simple argument to make looking at the pleadings. Benchmark alleges in paragraph 14 of their second amended petition that they had provided some quotes to KDOR and grandmothers, that these quotes were then accepted. And then in paragraph 17, significantly, KDOR and grandmothers memorialized the agreement in this third amendment lease. Benchmark is now
the exact language, memorialize the agreement.
the exact language, sir, is KDOR and grandmothers memorialized the agreement by executing the third amendment to the lease attached hereto as exhibit 1, and then it's selectively quoted.
And that was paragraph 17,
17,
I'm sorry.
Okay, run that past me one more time.
the language of it. KDOR and grandmothers memorialized the agreement by executing the third amendment to lease attached hereto as exhibit 1,
Okay,
which
so
states.
they memorialized it by doing that, but not in that agreement.
I'm not sure what the question you're after
Okay.
is there. Our point in citing that language is that this is the content of the agreement that Benchmark is alleging was reached between the parties.
The amendment.
Yes, the amendment to the lease, although it's between KDOR and grandmothers and not Benchmark, nevertheless memorializes the agreement that they have alleged all three parties entered into together, the content of what that agreement was. And then they go ahead and cite the content of the agreement that was memorialized in the lease. And as the court takes a look at that language, I won't read the whole of it, but you can see that what is being agreed to is that KDOR is going to pay the amount of the quotes to the landlord who actually owns the building. And the landlord, grandmothers, will pay in turn a Benchmark. That, we argue, is the agreement that even they're alleging in the pleadings that we entered into together. There's no dispute that KDOR paid the amount to the landlord. They assert that within the contents of the pleadings. As we proceed ahead in the petition, this issue.
Interrupt you for just a moment.
Yes.
What is your response to counsel's argument that the district court overstepped or did not conduct a proper hearing with respect to the judgment on the pleadings involving KDOR?
The district court specifically refers to the standard to be used in evaluating a motion for judgment on the pleadings, and asserts that it is applying that. It does use at certain points some confusing language about, no documentation being provided we still believe that the district court arrived at a sound conclusion, even if they used language that isn't applicable to this kind of a motion. And if this court finds that that was erroneous language to use, that can still uphold the district court's ultimate decision for being right on the wrong reasons there.
Thank you.
As we move ahead in the petition itself, Benchmark returns to the content of this contract or this agreement that they're alleging existed between the parties. You've heard counsel insist that, well, we alleged that there was a contract, and they did allege that, but they alleged what the content of that contract is. And again, we see that in paragraphs 46 and following. They say in, did you have a question, Judge? Okay. They say in paragraph 46, on or about September 5th, 2018, and I'll pause just to comment that as the court reviews the record, you'll notice that that date, September 5th, is the same date that the third amendment to the lease was executed. On or about that date, Benchmark Grandmothers and Cador entered into a valid enforceable agreement pursuant to which Benchmark agreed to perform the work identified in, and again, they cite to what they attached to the pleadings, which was the lease between Grandmothers and the Department of Revenue. And then they go on in paragraph 47 to assert Cador agreed to pay Grandmothers the total amount to Benchmark of a certain amount to pay to Benchmark upon Benchmark's completion of the work. Grandmothers agreed to pay Benchmark for its work on the project. This agreement was supported by adequate consideration. Benchmark completed the work, Cador paid the full amount. In their own recitation of what went on, this agreement between the three parties, they tell the court what it was that Cador was agreeing to do, and they tell the court Cador did that. And yet they want to proceed ahead then to assert later on in the petition that Cador breached this agreement. How? By failing to ensure that Benchmark received payment for its work, which is something different than what they had alleged this agreement between these three parties was even earlier in the pleadings itself. The Benchmark, within the contents of its own pleadings in paragraph 35, is appealing to the contents of the third amended lease to give evidence to what the contractual obligations were between all three parties. In paragraph 35, they talk about Grandmothers withholding certain money, and they say, pursuant to the third amendment to the lease, payment for Benchmark's work was to be contingent only on acceptance of the work of Cador. So time and again, what Benchmark is doing is they've given the court this lease. They said, this lease memorializes the agreement that we entered into. They're appealing to the lease to say what should or should not have happened. And yet they want to say that even though Cador has done everything it was obliged to under the terms of this agreement, somehow Cador is still on the hook for Grandmother's failure to pay the full amount to Benchmark. We believe that even just looking at those allegations, the court can come to the conclusion that they haven't laid out that there was a contract that Cador has breached here, and this case should be resolved in favor of the department on this issue.
Any other questions?
Thank you.
You have about 7.5 minutes.
Okay, thank you. May it please the court, I'm Christine Kaplinger, and I'm appearing on behalf of the appellees, Grandmothers and Mr. Robert Zabel. As far as the first thing that this court has asked us to do that has not seemingly been addressed by the appellant in her original brief and her oral argument is the ability for this court to hear it based on jurisdiction. As you know, appellate jurisdiction is purely statutory, and you can only exercise that jurisdiction under the circumstances allowed by statute. Benchmark filed this appeal under 60-2102 A4 as a final order. A final order obviously is a final decision. The summary judgment in case of grandmothers and Mr. Zabel, the district court granted it in favor of grandmothers on 4 causes of action: breach of contract, and both Kansas Fairness and Private Construction Act and the Public Construction Act, and the foreclosure of the mechanics lien. Upon the resulting journal entry in January of 2020, or 21, I apologize, granting summary judgment for those, the remaining claims against grandmothers by Benchmark was tortious interference with a contract, unjust enrichment, and conversion. In order to take this upon appeal, the appellate Benchmark dismissed all remaining claims with prejudice. The statutes and case law don't have historically determined that a motion for summary judgment is not a final order. It does not dispose of the entire merits of the controversy and continues to reserve further questions. It is generally not a final appealable decision, and such order granting partial judgment, because this was also it was summary judgment for not all of the claims, then it was unable to determine that it's a final judgment. There are 3 different ways, as you know, that the court has jurisdiction to hear a case. Obviously, 60-2102 A4 is a final order, KSA 60-2102 C, and then KSA 60-254 B, which is a certification of a final judgment. The Benchmark did not follow any of the proper procedures that would allow it to be heard today. It had 2 different options. It could have let the case be heard all the way through all causes of action. It also could have, and that would have made it a final order. It could have asked for interlocutory appeal. It could have also dismissed the claims with prejudice, meaning the entire order would have been complete. However, it made a motion in March of 2020 that to dismiss with prejudice for the purpose of appealing this case. Even doing so, when they did it without prejudice, there was not a guys here. The other thing that they could have done in order to see that through, even if had been without prejudice, would have been to certify the order by the district court with KSA 6254 B, which it did not do. It still has not done. Another issue that could arise here, if the court decides it does not have jurisdiction, is that is under the saving statute of 60-518. The appellate has said that well, first and foremost, the piecemeal, until that saving statute, by dismissing those claims without prejudice, the remaining claims still could have been brought before the district court, even if it had been capable of hearing through if this court had been capable of hearing all of the already decided on opinions there. The appellate has made in her reply brief that it doesn't really matter whether or not the saving statute has ran already. The saving statute would have been, so those claims cannot be relitigated. However, that's not what happened. It wasn't part of the saving statute when it was appealed. So it was not a final order at the time of the appeal. Just because it happens to be a final order today does not mean that it was a final order upon the time in which she filed a notice of appeal. as far as the arguments for the. Oh, and one last remaining thing is that the motion to dismiss was filed by Benchmark and Benchmark alone. We agreed to allow Benchmark to dismiss its claims in district court. But it was not by its motion. It may have been an agreed order, but it was not at the agreement of my clients.
But you didn't object. You could have objected and said we would like it dismissed with prejudice.
Yes, we could have. Yeah, this is correct. Yep. As far as the remaining time that I have here, I wanted to briefly talk about the arguments here. The appellate Benchmark has failed to prove that there was a contract that existed. Part of it was that there was no meeting of the minds and no implied contract. The only evidence that it shows the court is a lease amendment between KDOR and my clients. Benchmark was only contemplated in the lease provision with as to the quotes.
Can I ask you, why did grandmothers pay money to Benchmark? Then if there's no agreement, why did they pay money? Isn't that evidence of an agreement?
That money would have been evidence of an agreement between KDOR and Benchmark. The only obligation that my clients had to anybody was the only obligation my clients had to pay Benchmark was pursuant to an agreement with KDOR.
But that's not, when you review the deposition with Mr. Zabel, that he specifically says on page 42 that I said, if I have to do this work, be the middleman between the two, I deserve a 5% fee. And acknowledges that he had, yes, this was an oral agreement I had with Mr. Macbeth from Benchmark, and that's on page 43 of his deposition. How does that not undercut the assertion that this was only an agreement between KDOR and Benchmark?
Well, Robert Zabel also in his deposition said that he never intended to be bound by Benchmark as in contract with Benchmark. I don't think he cared as to who was hired to do, but it was KDOR's responsibility to determine who was used as a contractor. Any determinations were made between KDOR and Benchmark.
He says I had an oral agreement with Mr. Macbeth from Benchmark.
Yes, he has an oral, he said that, but I believe he also, let me put it this way. If any oral agreement did exist, it was not a written or a substantiated, memorialized agreement.
It doesn't have to be, because then we look at his conduct of he paid the majority of the fees.
Correct. And the majority of the remaining fees have been offered in an offer of judgment. The crux of this particular issue right now is that I will admit that Mr. Zabel owed that particular money. However, he felt that was it was a difference of opinion. It was a difference in the meeting of the minds. And any agreement that if the court could find that there was an equitable remedy as to whether or not Benchmark was owed any money by Mr. Zabel and grandmothers, it would have been through the unjust enrichment claims that the appellate dismissed. What she's really trying to claim here is she wants Benchmark wants an agreement to be enforceable under the Kansas Fairness and Private Construction Act, which requires a contract to be had. It also requires a contract with an owner. The equitable principles of what she dismissed would have been could have made Benchmark whole, and by doing that and by dismissing him, it's forcing the issue of the Kansas Fairness and Private Construction Act. What the issue is, I think that's most important to talk about, is that the issue of this appeal was to determine that to reverse the Kansas Fairness in Private Construction Act, the summary judgment in favor of my clients, because then they would get attorney's fees. It is even noted in the transcript of the motion hearing.
Your time has lapsed, so if you would like to go ahead and wrap up with just a couple
Yes.
thoughts, you may do so.
Yeah, I first and foremost, as a deal with the jurisdiction issue, we don't believe that this court has jurisdiction to hear this issue, as it is not a final order, nor was it ever certified as one. And that Benchmark and Grandmothers never had an enforceable agreement. Thank you.
Phyllis, you have 3 minutes rebuttal remaining.
Thank you, Your Honors. Briefly on the dismissal issue. This is a complete red herring. My client dismissed the additional equitable claims without prejudice. The time to refile them expired long before there was any briefing on this case. It gives him a period of breather to decide which track he wants to pursue. That happens all the time. I don't know how many cases I've had where somebody's filed extra claims against extra parties. They do a little bit of discovery. They dismiss somebody without prejudice. The case goes on. We have a jury trial, and then that jury trial verdict gets appealed. Is that if that's the rule, then every single one of those cases has a claim that was dismissed without prejudice that leaves that open. And that's,
I think I'm more interested in the summary judgment component.
yes, with respect to the summary judgment, Benchmark property remodeling didn't have to prove the existence of a contract to avoid summary judgment. Grandmothers is the non-moving party, or is the moving party. They have to affirmatively prove the non-existence of a contract, viewing all of the facts and everything before the court in the light most favorable to Benchmark. That absolutely did not occur here, and I think that's clear from the court's order. The fact that Mr. Zibel made all kinds of comments about what these oral agreements he claims to have had with Mr. Macbeth, who was paying who, what he wanted to do. What the court essentially did in saying, well, there's no meeting of the minds, is weigh the credibility of the witnesses based on their deposition testimony, which is absolutely not allowed in reviewing summary judgment. In the cases I cited with respect to the Prompt Pay Act, I think it was the Hilton case, the court noted that it held an evidentiary hearing where it brought in the equivalent of Mr. Zibel and the equivalent of Mr. Macbeth and heard live testimony about the parties' agreement, about the circumstances of the case, who did what and where, and then made the decision that the contractor that was claiming there was no contract was not credible and based the decision off of that. So if the court is saying that they say, well, Mr. Zibel says there was an agreement for 5%, Mr. Macbeth says there wasn't, no meeting of the minds, every single case, we're going to have somebody that comes in and says, well, there was no meeting of the minds. I disagree with that. That's an issue of fact that the court absolutely cannot decide on summary judgment in favor of a moving party. So I think that again underscores the fact that we just don't have, there's just not a basis for summary judgment in this case. Now we've heard, I think from both sides now, KDOR says, well, they needed to get money from Grandmothers. Grandmother said, well, your only agreement was with KDOR. That's the crux of my client's problem.
Can you address Mr. King's point on behalf of KDOR that everything the judge relied on was straight out of your petition?
Yes, and I would first of all point to a paragraph that was skipped over, which was paragraph 16. KDOR and Grandmothers accepted Benchmark's quotes and agreed to pay Benchmark $136,052.39 for the work in accordance with the quotes. I've alleged that both the parties agreed to pay. So, you know, my second amended petition is painfully detailed given the weird situation we have. I can only work with what I've got in terms of the facts, but the fact of the matter is that KDOR brought my client in to bid this work and said, hey, I'll pay you $136,000, turned around and entered into a lease with Grandmothers for $136,000, which is silent as to who's paying Benchmark, and then expects my client to be the one to, you know, sort through this. This is a dispute between grandmothers and KDOR. If KDOR wants to bring a claim against grandmothers and say, hey, you were supposed to pay this guy, that's fine, but that's not in the lease. The lease is silent as to anybody paying Benchmark. And that's the issue, I guess, I have with all of this. And I think another point that underscores the lack of summary judgment and the lack of judgment on the pleadings is you've got and I think the court quoted the email in one of the two orders.
Your time has lapsed. If you'd like to just quickly wrap up your thoughts.
Sure, I was just gonna say that we have a quote that was prepared by Benchmark, offering to perform work for a designated price with Benchmark's name at the top. The lease says we're gonna pay this amount for Benchmark's work. There's no agreement as to who's paying Benchmark, but it's pretty obvious from the KDOR's email cited by the court that KDOR expected Benchmark to perform that work. There's no guarantee to payment to my client, and my client is not the one that bears the burden of that risk. So I would ask that this court reverse summary judgment with respect to grandmothers and reverse judgment on the pleadings with respect to KDOR.
Thank you both for your arguments. We will take the matter under advisement and issue an opinion as quickly as we can. Thank you.